May it please the court and good morning. I'm Marcia Silvers on behalf of Vanessa Calderon. I'd like to respectfully reserve 2 minutes for rebuttal. Your Honor, we've raised several points in our brief, and the first issue that I'd like to address is that the evidence was insufficient to establish that Ms. Calderon knew that cocaine was being purchased and that she knew that the amount was over 400 grams of cocaine. This was an entirely circumstantial case, as the court is aware, and there are a couple of key facts that I think are important. First, Ms. Calderon was not at any of the meetings or in any of the phone calls that were the pre-arrangements for the purchase. At the Denny's on the day of the purchase, Medina, who's the co-defendant, said for the first time, "I was supposed to have the money today, but I don't." And then he says, for the very first time, after all this time leading up to here, he says, a woman is going to be coming with some money, and it belongs to her girlfriend. He then, at the prompting of the agent, calls the woman to see where she is. He never says that this woman knows about the cocaine. He never says that this woman is his partner. He just says she's coming and she's bringing some money that belongs to somebody else. And then after that, police observed Ms. Calderon arrive in the parking lot and put a bag in his car. And then, and I think this is important, she drives to the other side of the parking lot, which is 50 yards away. There's a separate parking lot for the Denny's, and then there's a separate parking lot for the stores in the shopping plaza. And she drives over to that side where she parks, and she doesn't just sit in the car like she's a lookout. She actually gets out of the car, and this all happens in the...
How long was she in the car after she parked?
That's a good question, Your Honor. The detective who testified about this, who did the surveillance, Detective Jones, said that it was just a short time, just a few minutes, from the time she left Medina's car until the time that she was arrested. It all happened very quickly. So this parking evidence is not inconsistent with her parking with the intention of going into one of the stores.
Was she arrested outside the store?
She was arrested outside her car. She got out of her car, and they were videotaping this, but they elected not to introduce the videotape. So we don't know exactly where she was standing, but she got out of her car, and that is clear on the record. So then that leaves us with her post-arrest statements. And she did voluntarily speak with the police, and part of it was recorded, part of it was not recorded. During the recorded parts, she asks the police what she's charged with. The police say that she was behaving as if she didn't know what she was charged with. She does tell them that I was dropping money off to Medina and that it was $8,000. And but the police admit that she does not state that it was for a drug transaction.
Does she have to? I mean, you say this is a circumstantial case.
Yes.
Well, she drives up and she takes $8,000, it's in a suitcase or a satchel of some kind, and puts it into an unlocked car, and then drives a short distance away and then parks the car where she can see the van. Right? That doesn't happen every day, does it? I mean, can't the circumstances be enough for a jury to conclude that she was part of
Well,
this?
the circumstantial evidence has to be inconsistent with a reasonable hypothesis of innocence.
What's the hypothesis of innocence in that situation?
I would submit, Your Honor, that there is a reasonable hypothesis of innocence that she didn't know of or agree to buy cocaine, much less the 400 grams.
Well, what is it?
It could have been any number of non-drug related transactions that he happened to call her up at the last minute and tell her about. Maybe he's telling her, look, they knew each other. They knew each other for years. They had a relationship, and she said that, and I don't think it was disputed. And so they trusted each other, and who knows? I don't know, but maybe he said, I have a gambling debt. I don't want you to get involved in it. I need you to drop some money off for me. I don't know.
The defendant and Medina, or?
Yes.
So what about this other woman?
The CI?
No, the one that isn't there a claim that she was dropping off for somebody else? The money from her or the money from?
The money belonged, no one knows who the money really belonged to, but Medina said the money belonged to Ms. Calderon's girlfriend.
Okay,
Yes.
so it's not, so Medina thinks the money's coming from the girlfriend,
Yes.
okay, but he knows Miss Calderon.
But he knows her.
Okay.
Yes.
Now, your case in your brief, I'm not sure if I'm pronouncing it right, dejuiced,
Yes.
which seems very similar, but the one difference is in dejuiced in the court, this court, made note of the fact that the appellant in that case was acquitted on the trafficking charge, which is different.
That is
than
different,
here.
but I think actually the facts of dejuiced are worse because she was found in possession of a prescription bottle of OxyContin, and she also had the marked money that was used for the purchase, of the OxyContin. So I would submit that that case is actually a case that has stronger facts, and in that case, this court reversed the conspiracy conviction and said that even if a person has knowledge of the crime, or even if they aided others in the commission of the crime, that's not adequate to sustain a conspiracy conviction, since there was not evidence of any meetings, conversation, or prearrangements between the defendant and the co-conspirator, and it was reversed for that reason. And I would say, this case, there's less evidence than in dejuiced.
So all you have here, you're saying, is Medina saying, this third party is sending me money, and then the money comes.
Yes.
And that's pretty much it. It's not saying my co-conspirator,
Or that she knows it's
my partner,
cocaine.
my cocaine partner.
No, he never says anything like that.
But you also have her statements.
Yes, and I was just going to get to those, Your Honor.
Yeah, because the thing that's troubling about her statements is that she behaves as if it's drugs. I mean, she doesn't behave as if it's paying off a gambling debt.
Well-
She behaves by offering to flip and work undercover, and stuff, does
Well,
she not?
she says, it's not really clear exactly what she says, because that part's not recorded.
Well, it's
But-
what the police,
Yeah.
the state gets the advantage of whatever the police
Yeah,
said. And,
I agree, Your Honor. But what they basically summarize her as saying is they tell her that these are really serious charges here, and you're going to be charged with, and then she says, well, how can I cooperate with you guys? She's still not saying, like, how can I do a drug deal, or how can I set him up, or even admitting that she knows anything, that she agreed to buy a kilogram of cocaine with him.
No, what she says is that, well, if you had me on tape, and I'm going to paraphrase, then I'm screwed, right? I mean, that's
She says, they tell her that, yes, that there may have been a wiretap, and then she responds, I'm fucked, and this was supposed to be an easy transaction. Now, I don't know, that's still, Your Honor, that's not.
Doesn't sound like a gambling debt, does it?
She's not saying, well, it doesn't exclude every reasonable hypothesis. It could have been any kind of transaction.
That's what I'm
We
like, I
don't
mean,
know.
tell me a reasonable hypothesis that fits in that with that circumstance.
Well,
Money owed to him for
If
some
gambling's
improper reason,
illegal,
any
wouldn't-
improper reason.
If gambling's illegal, wouldn't that still be couldn't that be a ground for her to say what she said?
Yes,
That's hang off a gambling debt.
yes. And then, Your Honors,
Is it
I think
criminal
it's-
to give somebody money to pay off an illegal debt? Is it criminal?
It depends on how much she knew. I mean, there's no,
So-
we're all speculating
matter?
here. That's the problem. This is a case where I think that the Florida Supreme Court's case in Lindsay and a number of other cases where they reverse, where they say that, yes, there are circumstances in cases sometimes that raise a suspicion. And that that can still, in such circumstances, even though the evidence would tend to justify the suspicion, that is not enough to say that the evidence is sufficient. And that's the case here, I would submit. And also, Your Honor, I do want to get to the issue of the fact that the state presented no evidence that she intended to and agreed to buy the 28 grams of cocaine required for first-degree trafficking, much less the 400 grams required to get the 15-year minimum mandatory. And I've cited the Florida Supreme Court case of Hernandez, where somebody thought they were purchasing $30,000 worth of cocaine, and because there was no evidence as to the worth of the cocaine, no evidence regarding the quantity, that the person knew of the quantity, the court said that they could not be convicted. And I think those cases are very strong. And also, I'd like to finally, Your Honor, address the improper admission of Medina's hearsay statements under 90.803(18)E. The only evidence that was independent of Medina's hearsay statements is the evidence that she put the bag in the car, that she parked the car near the stores before she was quickly arrested, and that she made these statements where she never admits that she was buying cocaine or knew about. So the evidence feels that evidence alone does not establish a conspiracy, I would submit. And there has to be, before co-conspirator statements can be admitted, the state has to prove by independent evidence, without consideration of the hearsay statements of Medina, that she participated in the trafficking conspiracy.
Well, don't her statements meet that criteria?
I would submit not, Your Honor, because without his statements, her statements don't really add up to her participating in a cocaine trafficking conspiracy. They're too ambiguous, I would submit, Your Honor. And I think that this, since these statements of Medina, which were legion in the trial, weren't admissible, they should not be permitted to even be considered when the court is considering the sufficiency of the evidence issue. And so I would submit that that is another good issue that we have, and that this was not harmless error, because Medina's statements were a real feature of the trial, and the state relied upon them heavily during the closing arguments. So unless the court has any further questions, I would rest.
Okay, so
May it please the court, Mitchell Egbert on behalf of the state of Florida.
So Mr. Egbert, so she brings $8,000 to, puts it in the van. I mean, is $8,000, is there evidence that $8,000 is enough to be a trafficking weight of cocaine?
Yes, Your Honor.
And what was that evidence?
The jury was informed that the buy was supposed to be for 1 kilogram of cocaine. The jury was informed that a kilogram, it was actually, the amount was 1,005.
How much is a kilogram? What's the retail price?
It was 25,000.
Okay, so she
That's what the
brings
jury-
eight into 25 is what? It's like one third of them, a little over one third.
That's correct. So we know that it's certainly more than 28 grams.
Okay.
We know that, based on that. I would also note that in her testimony,
Doesn't she have to get over 400 grams?
I was about to say that in her testimony, in the officer's testimony, in her actual recorded statement, and I'm going to give the court transcript numbers, transcript 400, she stated that she brought $8,000, but she was originally supposed to bring $17,000. So I think, yes, there is evidence that was presented to the jury and to the court that the cocaine was a kilogram, 25,000. The exact weight of the cocaine was 1,005 grams. And so we're way beyond 28 grams.
Who said she was
400.
supposed to bring 17,000? She said?
That's what she told the officer in her recorded statement. And going back to the statement, because I think that counsel has posited two. First, I would submit under either standard of direct evidence or circumstantial evidence, I think that this court must affirm the trial court. I think there's competent substantial evidence for that. The two hypotheses of innocence we keep hearing this morning is about a gambling debt. The only two times gambling is mentioned in the transcript is in the opening argument and the closing argument. There is no evidence of a reasonable hypothesis. What is the reasonable hypothesis of innocence? Judge Queensmith asked that question several times. I don't know what it is in this case. There was no indication through cross-examination of the police officers that Mr. Medina was even a gambler. We could make it for anything. Venetian blinds, furniture. I think it was in the Venetian blind business. Furniture. The fact of the matter is that we don't know there was no reasonable hypothesis of innocence given in this case. Second, we don't know from the transcript where she was arrested, whether she was inside or outside the vehicle. But let's assume for argument's sake that she was arrested outside the vehicle. Officer Jones was the one in the case at transcript 528 to 529 who observed and had her, was watching the defendant the entire time. She said that she was sitting in her vehicle, she was on her phone, and even when she was on her phone, I guess, speaking, she had a beeline to where his vehicle was. She never took her, testified, she never took her eyes off that vehicle where that transaction was supposed to take place when he went out and got the money that she had left there plus the other money in the vehicle. She said at one point she believes she left the vehicle, but she didn't leave the vicinity of the vehicle. She stood next to the vehicle. She was standing right next to it, and at that same time, the entire time was watching Mr. Medina's vehicle.
Now, didn't Medina...
So she wasn't walking, she wasn't going to go shopping.
Didn't Medina tell the undercover officer that the person who's bringing the money was bringing it on behalf of somebody else? Or words to that effect?
No, I don't believe that that's what he said. First, there was a meeting in January, the first meeting. He indicated that there was a female. Did not describe the female, did not give her name, who was involved in the transaction. At the meeting at Denny's, where the transaction took place, he described the individual coming as of Peruvian descent, a person that he knew. He also said that she was gay and that she looked like a man. When she arrived, the officer stated, yes, she does look like a man, and he actually described the individual coming bringing the money. So there's no question that, and she acknowledged, the defendant in this case acknowledged that she was the one on the other side of the phone calls. It wasn't just that he said, I'm calling the individual. She acknowledged that she was the one on the other side of the phone call. And let me just say something about those phone calls. The phone calls weren't made to set up initially the transaction. Those phone calls were made to direct her to where he was, where his vehicle was. So clearly, before those phone calls were made, there had already been an agreement. And that's where I want to get to her statement, because I know the court had a lot of questions about it. And beyond the fact that she left the $8,000 in an unlocked door, which was unlocked for her and to be put in that specific place, beyond the fact that she waited there for the transaction to occur, beyond the fact she received several calls from Mr. Medina as to where the car was and how long is it going to take her to get there, beyond the fact that she stated that she thought it was originally $17,000, she gives a statement to the police. And the context of a statement is very important. It has nothing to do with gambling, it has nothing to do with Venetian blind sales, it has nothing to do with furniture sales. It is about the sale of a kilogram of cocaine. And here's what happened. The officer stated to her, after she had given her recorded statement as she was walking to the elevator, he said, what if I told you that I wiretapped your phone calls with you and Mr. Medina? And she stated, I'm effed. This was supposed to be an easy transaction, buying and selling transaction. But more importantly, to give context, to show knowledge of how much cocaine there was, knowledge of how much it cost, and knowledge that she was part of a conspiracy, and aiding and abetting in this sale, she stated, quote, page 336 of the transcript, Ms. Calderon then stated that you know why I was here and I brought the money to you. Can we have any further explicit, clear knowledge on the part of a defendant who's been told by the officer? We don't need to know what the officers, he didn't need to say, why would he say it as far as his investigation, that, oh, I heard you talking about the sale of cocaine on the phone. He just said, I wiretapped the call. Everyone knows why they're there at this point. It's the only thing discussed in the 600 pages of transcript, other narcotics. And she said, you know why I was here, and I brought the money to Yule. How can I help you? To me, that's explicit and clear.
So that's how you would distinguish this case from DeJuiced, because in DeJuiced, she gave, she didn't make any such incriminating.
No, she did. As a matter of fact, in DeJuice, she actually testified, the defendant in that case, and gave a reasonable hypothesis of innocence that she was getting money for her boyfriend to pay off his rent. We have nothing. I'm not saying the defendant had to testify in this case, but we have nothing here. Again, the gambling debt is a red herring. We can pull anything out of thin air. And I suppose the reason it's been discussed is because that was what the defense counsel raised in opening and closing. You will never find the word gambling anywhere else in this transcript. So we would ask, if there are no further questions, we would respectfully ask that the court affirm the conviction.
Okay, Mr. Egbert, thank you.
Thank you.
Yes, Your Honor. On page 598 of the transcript, Medina says on the tape, this is her girlfriend's money. That's at page 598 of the transcript. Also, Your Honors, the post-arrest statements
But
don't...
does that make a difference? I mean, let's say she's just a courier for the money. I mean, that starts not her money, but she's, I don't know what you call it, the courier, the transporter. I mean, does that absolve her of being involved in a conspiracy even if she doesn't own the money?
I think it's just another good circumstantial fact for her that to show that she didn't know that she was there for the purchase of 1 kilogram of cocaine. Somebody gave her some money, her girlfriend, and said, take this money to so-and-so who you know he needs it. That's a better fact for her, I think, Your Honor.
Hey, how about that quote that Mr. Egbert just gave?
Your Honor,
At the police station.
the quote that I have written down on page 428 is that, this is unrecorded, is that after she was arrested, the detective explained what she was being charged with, and she said, quote, I'm going to be looking at a significant amount of jail time, and I want to put myself in a position where I can work for you. Okay? That's what she said. She was trying to cooperate. She was scared. I don't think that that's necessarily an admission that she knew that there was 1 kilogram of cocaine involved here.
Didn't you say, we know why I'm here? Or-
I don't recall that at all, Your Honor. And I've just reread all my notes of her statements.
After,
So-
I'm sorry,
Yeah.
Go ahead.
after you filed your brief in this case, the Supreme Court of Florida decided a case called Knight versus State. Are you familiar with that?
No, I'm not, Your Honor, but
Let me just tell you, this is
Yes.
what they said. I mean, they said, we now expressly hold that the circumstantial evidence standard of review applies only where all of the evidence of a defendant's guilt, i.e., the evidence tending to show that the defendant committed or participated in the crime, is circumstantial, not where any particular element of a crime is demonstrated exclusively by circumstantial evidence. That's sort of, we had not, we'd applied that standard for elements of crimes like intent. So here, isn't there direct evidence of her participation when she refers to a transaction? She says, I'm effed, I mean, those types of things. Isn't that direct evidence that would mean the circumstantial evidence standard
I would submit,
doesn't
Your
apply?
Honor, if she had admitted that she was involved in this, that would be direct evidence of her involvement. But here, that's just a statement, an ambiguous statement that can be interpreted in a number of different ways, and that's just another one of the circumstances.
Okay.
And with that, I thank you, Your
Okay,
Honor.
Ms. Silvers, thank you. Okay, we have concluded the